Good afternoon, everybody. I am Rhett Larson, School and Student Safety Specialist for the Utah State Board of Education. Welcome to our Safe and Healthy Schools webinar series. There are a few items of business before we begin. For those who cannot participate today, a recording will be posted to our Safe and Healthy Schools events and trainings page. One relicensure hour is available for participants who complete the required questionnaire. The link to the questionnaire will also be posted on the events and trainings page for 1 month from today. There will be a question and answer portion at the end of the presentation. At that time, you may submit your questions in the chat box. We ask that you remember virtual meeting etiquette and keep your microphones muted. We look forward to having you join us for our future webinars. The topic for March is mental health and will be held at 11 a.m. on March 23rd. I will now turn the time over to Sergeant Jeremy Barnes.
Thank you. I am Sergeant Jeremy Barnes with the Utah Department of Public Safety, and I serve as the School Safety Liaison with the Utah State Board of Education School Safety Center. For those sworn members of law enforcement in attendance, please notify your department of this training so it can be reported for post credit. One of the roles of the School Safety Center is to identify and provide training regarding topics related to safety. This month, we are pleased to have Heidi Alder with us to speak about the importance of relationship building between school resource officers and school administrators. Heidi Alder splits her time as an attorney with the law firm of Lear & Lear and in-house attorney at Weber School District. In both these capacities, she provides guidance and counsel on a variety of legal issues, including FERPA, constitutional rights of students and teachers, employment law, special education and policy matters. Her work at Weber School District gives her an in-depth understanding of the inner workings of a school district, and her work with other districts and charters around the state gives her a breadth of exposure to LEAs and their differences. This combination puts Heidi in a unique position to understand the issues LEAs face on a macro and micro level. Heidi also spends much of her time providing trainings, like this one, to administrators, counselors, other attorneys, SROs, classified employees, charter schools, and any other organization she can convince to let her teach. Heidi has a recently expired Level 3 teaching license and began her career as a junior high history teacher in Davis School District. Heidi still teaches as an adjunct at Utah State University. She teaches education law to aspiring administrators. Heidi sat on the Children's Justice Center board for 10 years and served as vice chair and then chair of the board for the last 2 years. She currently sits on the board for Utah Legal Services and is an active member of the education law section of the Utah Bar. Heidi has a precocious 4-year-old who keeps her on her toes and a patent attorney for a husband who reminds her why she went into education law rather than what she considers to be the boring and technical part of the law that is patent work. And with that, I will turn it over to Heidi Alder.
Okay. Thank you, Sergeant Barnes. I appreciate the opportunity that I have to speak to everybody. And just so you know, I've got a split screen and my camera is below me and my screen that shows everyone is above me. So if it looks like I'm looking towards the sky, I'm just looking at my Zoom screen. And I want to just see by raise of hand, if you can do a little hand raise in the chat, how many here are law enforcement? We have about 62 participants. Okay. Okay. Awesome. Quite a few. Good. That's great. How many here are administrators at an LEA, either a charter or a district? Okay. And then the rest of you, those who didn't raise your hand, if you just take a second while I'm getting the presentation up and put in the chat what your role is, that'd be great. Just so I can have a sense of what who I'm talking to. We've got a school nurse, district nurse, fantastic. Counselor, awesome. Teacher, principal, good. Teacher, counselor, good. Student services coordinator, researcher, risk manager. Oh, that's always scary when the insurer is making sure the attorney is saying the right things. It's super helpful to see who it is that is here. This presentation is primarily focused towards SROs and administrators. And I'm going to go ahead and share my screen and begin with just a little bit of background. Let me get into my slide presentation. Okay. Just to give you some background, and there's more background on a national level, but not necessarily anything you need to know, but just to give you some context of where this training is coming from. Based on some findings from a 2015, so about 6 years ago, there was an assessment done of school-based law enforcement programs in Salt Lake County schools. It was Granite School District, Jordan Canyons, I believe. I might be missing one, Salt Lake School District. And following that assessment, the Utah legislature came to some findings. And as a result of the findings, the Utah legislature passed a law in 2016, which is now codified in that reference 53G 8702, which requires, among other things, the development of an MOU between school districts or LEAs, charters too, and law enforcement agencies, if there is a relationship, that includes a detailed description of job duties of SROs. So any LEA that has SROs in their school, there ought to be some kind of memorandum of understanding or a contract or an agreement, whatever you want to call it, that spells out the job description of SROs in the MOU. The law also requires that the school district and the law enforcement agency jointly discuss SRO applicants, and that the law enforcement agency allow the school district to provide feedback with regard to SRO's performance. And then the law requires training for school-based law enforcement and administrators. I know POST provides training for law enforcement, but this training is specific for administrators and SROs. The law actually outlines a number of topics that may be covered in the training. Things like childhood and adolescent development, responding age appropriately to students, working with disabled students, how to de-escalate and resolve conflict, cultural awareness, restorative justice practices. You can read through this list and see the rest of the suggested topics. It's maybe worth noting that there's currently a bill in the Utah legislature, HB 345, if you follow legislation, that if passed would require the training to cover all of these topics. Right now, I'm not aware of any one training that covers all of these topics. There would be, I think, 18 in total, because the bill adds a couple more topics too. And the training that administrators and SROs are required to have on an annual basis would cover all of these topics. I'm not qualified to cover all of these topics. I'm an attorney, I'm a former teacher. I can speak to my experience about childhood and adolescent development, both as a former child and also a teacher and a mother, but that isn't my area of expertise. So that's not what I'm going to talk about today. Same with working with disabled students. I can certainly speak to the legalities of disability law and special education, but it would be far more beneficial to have information coming from experts in that field. So just know that moving forward, there may be a requirement to have all of these topics covered in the annual administrator and SRO training. Today, I'm just going to talk about a couple of the things that come to me a lot as an attorney, the questions I get a lot. Primarily questions about searches and interrogations and how those work with administrators and SROs, and when administrators and SROs are combining forces in an investigation and questioning students and searching students, and what the various standards are for the administrator versus for the SRO. I'm also going to talk today about FERPA. I get tons of questions about education records and what can be shared with an SRO, and what can be shared with outside law enforcement, and what can't be shared, and how that plays out in terms of education records. So that's going to be my primary focus. But before I get into those two areas of the law, I want to start by just touching briefly on what you're seeing around you right now. What's making headline news? I did a search. This is probably, it's been a few months, as you can tell, but June, July, September, just even now, if you were to do a Google searches, type in school resource officers, you're going to see a ton of headlines all over the country where there's a push to get rid of school-based law enforcement. In Portland superintendent says he is discontinuing the presence of armed officers in schools. New York Times ran an article, do police officers make schools safer or more dangerous? The Washington Post ran an article, fueled by protests, school districts across the country cut ties with police. You can see the rest of the headlines where there is discussion nationwide about whether or not school-based law enforcement is helpful, or if in fact it's hurtful. And rather than bring those headlines to Utah, it would be a good idea to get ahead of it. So what can we do to help the public see that SROs are actually an important part of schools? I believe they are. I'll just give you my own personal opinion. I think that they can be a very useful part of the educational system. A, do we just ignore and wait it out because the headlines are going to go away? B, do we increase arrests at school? That'll show them. C, don't pursue any criminal activity. That'll show them. Or D, take the opportunity to become the kind of SRO that the public needs right now. And I hope that you all see that D is the best choice there. Administrators, you can be a huge help in this regard. Until there is a comprehensive training that covers all of these topics, there are people at your schools who do these things, and they can provide a primer on many of these topics. Get in touch with your special ed folks, get in touch with your counselors, get in touch with individuals who have expertise in childhood development, and have them provide a 20-30 minute training for your SROs that can give them the information that will help them be the kind of SRO that, again, schools need. Is there a question? I'm sorry, I talked over someone, I think. Okay, I'll continue until someone stops me. Be proactive, get in front of it. Show the public how valuable your law enforcement officers are. SROs have an incredibly unique role. Unlike other law enforcement, and I speak with complete honesty, I obviously don't come from law enforcement. I'm not a prosecutor. I've never been a prosecutor. So everything I know about what I'm talking about comes from my work with SROs in the schools. But from what I understand and from what I've seen, SROs are unique in that they are mentors, role models, teachers, educators, protectors, counselors, enforcers, instructors, guardians, defenders, advisors, and caretakers. All of these are different roles that an SRO has in a school. Breaking it out into three, perhaps umbrella roles, a teacher, an informal counselor, and a police officer, you can see how your duties under each of these roles play out. As a teacher, some of you may actually act as a member of the faculty. Some of you teach street law. Some of you teach classes or co-teach classes that give students information about what you do and about the basics of criminal law and criminal justice. Some of you provide law-related education to students, parents, and staff just upon request. Some of you do assemblies. Some of you do various trainings, or even informally sit down one-on-one and talk to folks. You're often, I know, advising administrators as to what is a criminal matter and what is not. Sometimes you fill the role of a guest speaker. As an informal counselor, you may find yourself counseling students and parents based on your expertise as a law enforcement officer. You may work closely with the counseling staff. You might be providing information on community services and the law to students, parents, and staff. And of course, as a police officer, you are at school as a uniformed or sometimes in plainclothes officer. You investigate crimes. You make arrests if necessary. You act as the officer for the school community. You work with other outside law enforcement officers and agencies. You can be the liaison between the school and the police community and provide that positive role model. And then obviously overarching all of these is ensuring a safer school community. Now, jumping to the role of a school administrator, let's talk about that for a second, because the school administrator has similar roles, but obviously very different from a law enforcement officer. As an instructional leader / teacher, you facilitate the development of a vision of learning. You advocate and nurture and sustain a school focused on teaching and learning. You design instruction for student success. As a counselor, you're always ensuring that the management and organization operation of everything is effective, and it is creating an effective learning environment. You make sure that as a disciplinarian, you are both counseling as well as disciplining, in that you are acting within a system of integrity and fairness. You create a positive school culture, or that's what one of your responsibilities is. And then of course, your general duties to ensure efficient school operations include overseeing day-to-day operational activities, responding to diverse community interests, etc. Now, SROs and administrators have shared roles. Both SROs and school administrators strive to create a safe environment for students inside and outside of school. It is probably our #1 goal, sometimes even above learning, is to make sure kids are safe at school, that they're not coming to school feeling threatened, feeling scared, or feeling like they're going to be subjected to violence or any other type of behavior that then will interfere with their education. If they don't feel safe, they can't learn. Second, both SROs and school administrators have to understand and respect students' rights. And that includes their privacy rights, which we'll talk about under FERPA. It includes their 4th Amendment rights, their 5th Amendment rights. And students are quick to tell you about their rights. They're no idiots when it comes to what rights they have. Sometimes they may be somewhat misinformed, but they are certainly prepared to let you know, as authority figures, that they have rights too, and they in fact do. To teach students respect for others. Another important role of SROs and administrators is to de-escalate school-based incidents. So much of what we see in the news is an incident that could not or was not de-escalated, and it blew up. And someone had a camera and it went viral. The whole, that is the opposite of creating a safe environment. Best practice for administrators and SROs, and there's no law that says you have to do this, but it is best practice to meet together on at least an annual basis. The SROs and administrators that I work with on a more regular basis in Weber District, they're talking every day. But on an annual basis, maybe have a formal meeting where you sit down and talk about the difference between disciplinary misconduct and criminal offenses. And again, these are things that most of you are doing every single day, but having that come to Jesus moment, if you will, where you're sitting down and talking to one another and actually going through some of these things, specifically focusing on these, could be really productive. Talk about different approaches that might reduce the number of arrests or court referrals. Maybe approaches that might reduce the number of suspensions. Right now, there's a big push nationally to keep kids in school. That whole school to prison pipeline is not going away. It's been around for a long time. That theory that as long as kids are being suspended, they are being put out on the streets and they're more likely to end up in prison. And there will continue to be a push to keep kids in school rather than to suspend them and to arrest them. So administrators, SROs, talk about that. Talk about different approaches. Bring your counselors in. Counselors are fantastic resources when it comes to alternative disciplinary methods. Restorative justice practice is a huge term of art these days. What does that even mean for law enforcement and for administrators? And how can the two of you implement restorative justice practices at your school so kids aren't being arrested and they're not being suspended, and yet you're still ensuring a disciplined school system? Because not arresting and not suspending doesn't mean that you're just letting kids run wild. It means that you're addressing the problem by getting at the root of it, not by taking a punitive approach. Talk about what it means to respect students' rights when searching and questioning. Talk about how to de-escalate. Again, that bringing it down instead of having it blow up where a kid ends up in handcuffs. That's the worst YouTube video out there, right? Where an 8-year-old special ed kid is in handcuffs. And of course, we don't know what happened before the video was filmed or after the video, but what we see is that elementary kid who's special needs being handcuffed by a police officer. And that's what happens when a situation is not de-escalated and then someone stands by with a camera and takes the worst part of it and makes it viral. Whatever you can do to bring situations down is going to save you a PR nightmare, if nothing else. Share information. If a student is involved in a criminal infraction, has an IEP, a 504 behavior plan, or otherwise requires accommodations. SROs may not be familiar with these acronyms, IEPs, 504s, BIPs. Talk to each other about what that means. For law enforcement, the law doesn't differentiate between people with special needs and people without, but it certainly does in schools, right? And so the more that you can share information, even about specific kids, talk about kids you're concerned about. Administrators, share information with SROs. That kid's on an IEP. That kid has an emotional disturbance. This is what that means. These are the accommodations the student is receiving. That kid may need a 504. Here's what that means. Have that information. SROs, to the extent that you can share, that kid was just arrested, or his mom was just arrested, and maybe that's why he's acting out, or his dad went back to jail for the 3rd time this year, and maybe that's why he's acting out or she's acting out.
That's what they got me, the girls, and then look at this, and then look at this card.
Are you planning on doing the episode?
Someone's
Right?
not on mute. I don't think they're talking to me. Okay. And then facilitate investigations and actions. Work together.
I showed this.
I'm going to skip forward now and talk a little bit about the 4th and 5th Amendments.
What's that?
Whose idea was this?
You know what? I think someone's still not on mute.
Yeah, well, everyone.
Can
please
everybody
check
check their screen and just make sure you're on mute? There we go. Thanks. I don't want to talk over anybody. If you have a question, by all means, please interrupt.
Heidi, I apologize. The screen you're sharing is your display view, not the actual. Like we can see like if you have notes in it.
Oh.
I don't know if that matters to you, but if you just go to the display settings up at the top.
Yeah.
Click.
Okay. Thanks. I appreciate that. Let me fix that real quick. There I am. Look at that. Sorry about that. Is that better?
Much better.
Okay. Now you don't get to see what comes next or any of my notes, but now you get to see what I intended for you to see. Okay. 4th Amendment. I'm not going to read all of it, but this is it in its entirety. The Search and Seizure Amendment says that people can't be searched and their things can't be seized without probable cause. Now, let's talk a little bit of background here. Most of you administrators at some point in your administrative law classes went through this case, New Jersey versus TLO, which is the landmark Supreme Court case that addresses search and seizures in schools. This was 1985, so we're talking 35 years ago, more than that, almost 45 years ago. And the facts there include, I always think it's interesting and helpful to get a sense of the background. So 2 girls, this is junior high, 14 years old, were caught smoking in a bathroom by a teacher who brought the girls down to the principal's office. One of the girls admitted it, but the other girl, initials TLO, denied it. The assistant principal searched TLO's purse and immediately found a pack of cigarettes, also a package of cigarette rolling paper. He continued to search, and just, it should be noted, he searched without her consent. So this was a consentless search. He continued to search, found a small amount of marijuana, a pipe, a number of empty plastic bags, a substantial quantity of $1 bills, and an index card that appeared to be a list of students who owed TLO money, and then 2 letters that implicated TLO in marijuana dealing. TLO was charged criminally, so she was suspended from school. Principal Choplik sent the information and all of the evidence over to law enforcement, and she was charged for possession and distribution. TLO, and through her parents, moved to suppress the evidence found in her purse on the basis that Mr. Choplik violated the Fourth Amendment in his search. Now, SROs, you know this backwards and forwards, but for those of you who are school folks, you know, either through shows or your own study, that if evidence is seized inappropriately, then the consequence is it can't be used to prosecute. It is the fruit of a poisonous search. And when law enforcement don't follow proper protocol, then the consequences, prosecutors can't use that evidence when prosecuting a case. And that's what this case is about. TLO said that the evidence of her marijuana dealing was seized inappropriately. Her purse was searched inappropriately. It was seized in violation of her Fourth Amendment rights. And so none of that evidence should be used in her criminal prosecution. So this question, just to be clear, it wasn't about whether or not she should be suspended or whether or not there should be school administrative discipline. This was a question of whether or not there should be criminal sanctions. So she was fighting this case in the context of a crime that she was being charged with outside of school. But her argument was that her school principal is the one that violated the Fourth Amendment. So the question for the court was, well, does a search of a student and or her belongings without probable cause violate the Fourth Amendment? If we're talking about schools and principals and teachers, where a huge part of their responsibilities is to make sure kids are safe, then do they have to have probable cause to search? And the answer was no. The court ruled for the school and said that a search of students by school officials, and I bolded that and italicized that because that's important. A search of students by school officials is permissible if it's reasonable and not excessively intrusive. So rather than this higher standard of probable cause, the Supreme Court said the school administrators, school officials have to have reasonable suspicion. Now, how does this standard apply to SROs? We'll get back to this reasonable suspicion standard in just a second. But how does it apply to SROs? Well, it doesn't. The Supreme Court expressly reserved judgment on the appropriate legal standard for searches conducted by school officials in conjunction with or at the behest of law enforcement. It's in footnote 7 there. And what it says is we are only considering searches carried out by school authorities acting alone and on their own authority. We're not talking about the question of whether or not a school official in conjunction with law enforcement is meets the same standard. So with that in mind, let's go back to the standard for administrators for a second. In order to meet the reasonable suspicion standard, an administrator has to be able to articulate two things: that the search was reasonably justified at its inception, and I'll explain that in a moment, and that the search was reasonably related in scope to the circumstances that justified the search in the first place, okay? As a side note, meeting the probable cause standard requires the same two things, but only more justification before initiating a search. So let's talk about these two things, breaking them down. What does that mean? Justified at its inception means you have to have some reasonable basis to start a search. For example, Jenny's walking down the hall and here's Johnny say, "I've got dope in my backpack." Jenny was an office aide last year. She's someone that you know is reliable. She has a reputation for honesty. Your decision to initiate a search is justified, okay? It also has to be reasonable in the scope of the search. Just because you have a basis, a reasonable and justifiable basis to search, doesn't give you the authority to go hog wild and search everything and everywhere. All you have is what Jenny told you, that she heard Johnny say, "I've got dope in my backpack." The scope of the search should be limited to Johnny's backpack. You probably can't expand your search to Johnny's car. What about Johnny's phone? Well, it depends on a whole lot of variety of facts. If there is a fact pattern, if it's part of the history that deals go down through text messages, and that Johnny himself, I'm just making these facts up, but Johnny himself has been involved in dealing in the past and has been, he's been suspended, he's even been charged criminally. and you know that he communicates with his clientele through his phone, through his text messaging, then maybe looking at his phone is appropriate. But if none of that stuff exists, it might not be. These analyses are very fact-based. Now let's look at, say, something where it might not be justified. Say, for example, Jenny tells you, I heard Johnny say he has dope in his backpack. But you know, because you're an administrator and you know way too many details about your kids' lives, that Johnny just broke up with Jenny. Jenny is heartbroken. You also know that Jenny's taking it really hard. You know that Johnny has never gotten in trouble for anything in his life. He doesn't have a single disciplinary matter in his record. And Jenny, on the other hand, has been to your office several times that year because she likes to spread rumors about people on social media and likes to try to get people in trouble. So with those facts, the search of Johnny's backpack is probably not justified. You probably don't have that reasonable suspicion. Again, that scope, that reasonableness and scope, the second prong of this analysis is going to see if it's not limited to where you believe the evidence is based on the information you have, is probably not reasonable in scope. But courts are very deferential to schools. Most of the cases, the school search cases, where a court said that is not reasonable in the scope of the search, the scope of the search was way beyond reasonable, involves strip searches. So just as a best practice, avoid asking students to take off clothes unless you have reasonable suspicion that the student is hiding something under his or her clothes that poses a serious and immediate threat to either himself or others. Strip searches should be avoided. Those are the cases that end up in court. Those are the cases that are going to tick off parents, and those are the cases that are going to have people yelling at you. So while you may at the end of the day win in court, you're going to want to just avoid those unless there's some immediate threat. Let's take a look at some of the factors that courts have looked at when deciding whether a search is reasonable at its inception. When to decide whether an administrator or another school official does in fact have reasonable suspicion to start a search. Well, prior offenses of the same or similar nature come up all the time. You know this kid is someone who he's someone who has been in trouble for vaping 100 times this year already. You've seen him not only vape yourself, you've personally observed it, he's admitted it. You've seen him share his Juul or whatever it is he's using with all of his friends. So prior offenses could be enough to give you reasonable suspicion, but probably not alone. Just because someone has in the past done something doesn't mean that you could just stop and search them any day, all day, right? That in combination with reports from reliable staff that the student in question might smell or has a smell of marijuana, I'm just throwing that particular drug of choice out, or has a bulge in his pocket. Reports by reliable students of observations of the student in question engaging in the misconduct. Reports by reliable students that the student in question confessed to engaging in the misconduct. Your own observations of slurred speech, glassy eyes, smell of alcohol or drugs. Those are all things that courts have looked at and said, yeah, if an administrator can articulate these things, that's fine, that's reasonable suspicion. At the end of the day, administrators, the thing that is going to be most helpful to you and your attorney, whoever that is, when and if you're ever sued for these things, is that you literally write down why you searched a kid. What was the reasons? What were the reasons that gave you what you felt was reasonable suspicion to search? Write them down. Be careful, because while reasonable suspicion, it is a pretty low standard. Again, courts are very deferential to schools in this arena, but courts are also wary of basing suspicion on things like, well, it was a suspicious denial. I asked him if he had alcohol in his backpack and he said no, but it was really suspicious the way he said it. So I searched his backpack anyway. Or acting weird without being able to articulate anything else. Acting weird is probably not going to be enough. Spell that out. What does that mean when someone's acting weird? Relying on students that you don't know and you can't speak to their reputation for honesty, that might also be problematic. If there's a history of discipline problems with a kid, but they're totally unrelated. Say the kid's a mouthy kid and he drops the F-bomb every time he sees you. He's insubordinate, he's mouthy, he's just a problem child. But to your knowledge, he's never been caught with pot. Stopping and searching the kid's backpack for pot when you hear there's a drug deal going down and saying, well, he's a disciplinary problem is probably not going to fly because he's not a disciplinary problem for this situation. He might be a mouthy kid, but that doesn't mean that he smokes pot or that he's dealing, right? Same example. Administrator stops kids walk. This is just another example. Administrator stops kids walking down the hall and searches his backpack because kids aren't supposed to be in the hall during the class. That's also not okay. Just because kids are doing something they're not supposed to do doesn't justify a search. Making sure this search of itself is reasonable in scope is also important. And just keep in mind, the more invasive the search, the stronger your basis for beginning the search needs to be. For example, if you conduct a strip search, you had better be able to articulate with clarity the exact reason for your suspicion that you would find contraband in the kid's clothes. So backpacks are not as private as the kid's underwear, for example. And I hope that goes without saying, and then I'm not giving anyone enlightened information here, but the more invasive the search, the more you're searching areas and parts of someone or in a place that's considered private, then you better be darn sure that the basis for your search, it ought to reach almost more to the probable cause level. Okay? Also, the more invasive your search, the more compelling your interest should be. So if you're conducting a strip search, and again, I would advise you not to, but as you get closer and closer to something like that, then you'd better be looking for something that poses a serious threat. In other words, don't ever do a strip search for a stolen calculator or something else that is not going to pose a significant and immediate threat. In addition, consider whether your search is, as you're considering whether your search is reasonable, think about how much privacy does a person legitimately expect to have in his or her locker. The answer to that is none, because most, and I hope that this is written into your LEA's policies. If it's not, go home right now and change that. But most LEAs have it written into their policy that the LEA, the district or the charter or the school itself owns the locker, and that kids' expectations to privacy in their locker should be zero. Social media posts. That's also probably not one that kids ought to expect much privacy in. I mean, social media by its nature is out there, right? Backpacks, more privacy. Pants pockets, more privacy. Purses, yeah. And then weigh that against how compelling the school's interest is in searching. Okay. Now, shifting back to SROs, searches conducted by SROs or at the request or direction of SROs ought to be based on the probable cause standard that law enforcement is subject to. Take a look at whether the search is related to a criminal investigation or a school infraction. If it's a criminal investigation, it ought to be that probable cause standard. Was the search initiated by school officials or by law enforcement? If law enforcement, it ought to be the probable cause standard. Is the SRO conducting the search at the request of the school, or is the SRO conducting the search on his own initiative? If the SRO is doing it in search of evidence of a crime, it needs to be that probable cause standard. Was the SRO actively participating in the search or merely present during an administrative search? If it's an active participation in the search, it probably ought to be that probable cause standard. Consider too whether an SRO is employed and paid by the school or a local law enforcement agency. And I know there's a whole lot of different ways LEAs engage with local law enforcement. Some have a salary sharing agreement where the LEA pays for half, the law enforcement agency pays for half. Sometimes the LEA reimburses the law enforcement agency. Sometimes it's just a sharing of resources where the law enforcement agency pays the full salary of the SRO and then provides other resources, or excuse me, the school district will provide resources to the law enforcement agency. Consider too, whether the SRO has other duties at the school besides just law enforcement. Is the SRO also a teacher, also an administrator? Or is the SRO strictly present to enforce law enforcement? If it's the latter, that probable cause standard is what is going to apply. Okay? Now, just a quick note, by no means am I saying that SROs and administrators can't work together in investigating and conducting searches. But as you're working together, consider these factors to sort of guide you as you work, as you do these searches. Obviously, a reasonable suspicion standard is a much lower standard than a probable cause standard. And so whenever you can, you're going to want to fall to that standard. But that means it needs to be a school-based search by a school official for a school infraction. And while the SRO can absolutely be a part of that and can guide you, because and the SRO has probably done a lot more searches than administrators have, then that's fine. But again, keep in mind the difference in terms of the purpose of the search and who's conducting it or initiating it. SROs, you should never, and I think that this goes without saying, but just to reiterate, you should never ask an administrator to conduct a search for you just to get around your probable cause standard. Search guidelines for both SROs and administrators, always ask for consent first. If the student consents, then none of the previous slides matter. If the student says, sure, you can look in my backpack, then you have consent and you're not conducting a search. But make sure the consent is given knowingly, right? Sometimes students don't know that they can refuse to give consent to search when it's their principal that's asking. So be careful of that one too. Oftentimes a principal may say something like, give me your bag. And just because the student gives the bag to the principal doesn't necessarily mean the student is giving consent. If the student does consent, then be sure your search is limited to what that consent is. Okay? Absent consent, searches that are wholly criminal in nature and have no relation to the school or school rules should probably be done by an SRO or another outside law enforcement agent under the probable cause standard. Searches involving school infractions should be initiated by school officials, not SROs. And again, it's permissible for the SROs to be present and to assist, but be careful that the search was initiated, led by, and done for the school purposes and school administration, and not for SRO or criminal purposes. Okay. Also, searches involving school infractions that are also criminal in nature, that happens all the time, right? Whether it's possession of marijuana or some kind of sexting scandal, sexual exploitation of a minor or something like that, may be done by the administrator at the lower reasonable suspicion standard. And then if the administrator is acting on reasonable suspicion and does come across evidence of a crime, it's totally appropriate for the administrator to turn that over to the SRO. And then the SRO has that evidence and can give it to the prosecutor, and the probable cause standard doesn't have to be met. So it's totally appropriate to do it that way. That's how TLO ended up being prosecuted. But again, SRO should not direct the administrator to conduct the search, just to get around that higher standard. Okay? I want to take a couple seconds and talk about cell phone searches, because a lot of evidence of misconduct and or crimes is contained in a kid's cell phone. Searches of cell phones may be performed by administrators if the administrator has reasonable suspicion that the student is violated a rule or law and that the evidence of the violation is on the cell phone. But keep in mind that the search has to be reasonable in scope. For example, you hear that someone cheated on his math test by texting himself the answers. Look at the texts. Not necessarily the student's pictures or emails or Snapchat or Instagram. Phones are like a purse. They're more of a purse. They're the person's entire life. And so if you have evidence, or if you have suspicion to believe that evidence of misconduct is contained somewhere in the student's phone, you better have a good idea of where, and then stick the search, stay within that app basically for your search. And then any related apps that are reasonably, that it's plausible that the evidence might be in those ones, but don't go fishing. What if a phone is locked, which it often is? Remember, first, ask for consent. If it's not provided, then consider these things. Weigh the expectation of privacy a student has in his or her phone, which these days courts are saying is quite a lot, with the school's interest in conducting the search. How serious is the allegation? How serious is the alleged infraction? Okay. Second, can you articulate your basis for reasonable suspicion? Why do you think that the kid's phone is going to give you evidence of his or her misconduct? Third, do you have the technical help to get into a locked phone? The kid gives you the phone and refuses to give you his or her password. Can you get into it? If you don't have the technical help, why bother? Fourth, is the allegation you're looking into criminal, such that maybe you should turn the phone over to law enforcement anyway and let them deal with it if they have probable cause. I would strongly, strongly discourage anyone from getting into a physical altercation with a student over their phone. If they're not going to give you the phone, don't go grabbing for it and get in a brawl in order to get the kid's phone out of his or her hands. Unless there's like some imminent, the bomb is in the locker and you know that the kid just sent a text message telling exactly what the code to the locker is and when it's going to go off. In that case, yeah, get the kid's phone at any cost. But short of that, getting into a physical altercation is not going to be worth it. Sexting cell phone guidance. If you have reason to believe that there's a sexting situation, get your SRO involved. Images may contain child pornography. 90% of your students, probably more than that, 95, anyone under 18 is a minor. So unless you only are a principal or a teacher of 18-year-olds and above, there's a good chance that any images of nude or partially nude students are going to be of quote unquote children or minors. Whatever you do, do not ask students to forward you images. If a student comes in and tells you, Johnny just showed me this picture of his girlfriend and she was naked and it was really uncomfortable, call Johnny down to the office with his phone. Don't ask the student, well, did he send you the picture and forward it to me? Or don't send the student back and tell the student, well, get Johnny to forward you the picture and then bring it into me. That is the child pornography distribution, and you don't want to be in the middle of that, okay? Now, when it comes to whether or not kids are actually going to be prosecuted for these things, it depends on the local prosecutor. Some are not going to do anything where students who are the same age are mutually exchanging nude or compromising images. But some prosecutors might if there's a clear victim. Okay? Your school needs to figure out how to handle these cases because they're rampant, they're not going away, and they're tough. They're also tough because as an administrator, you need to see evidence, but you do not want to see your students in a compromising position. So walk carefully, work with, if you have district officials, work with your risk management, work with your attorneys to sort of figure out how to handle evidence or rumors of a sexting scandal. And then SROs, work together with your administrators to investigate sexting if the sexting is occurring at school. If it's happening off grounds and it's really not disrupting the school, then that's going to be a law enforcement only problem. If it's happening at school, kids are talking about it at school, kids are sharing the pictures at school, then it becomes a school problem, and work with your SRO about how to handle that. Questioning students. First, must a student be given Miranda warnings when questioned at school by an administrator? What if the student is a minor? What if the student is in elementary? What if the SRO is with the administrator when questioning? What if the SRO is not with the student, but the SRO alone is questioning the student? Or what if the person questioning the student is an outside detective? For those of you who haven't watched enough Law and Order, Miranda warnings are you have the right to remain silent. Anything you say or do will be used, will be used against you in a court of law, et cetera, et cetera. And law enforcement are required to say that line anytime they are questioning someone in a situation that is considered a custodial interrogation. And that term custodial interrogation is very technical. Courts have broken those down and identified what custodial means and what interrogation means. But the first thing you need to know as administrators, for those of you who are administrators, is that you never are going to have an obligation to read a student a Miranda right. A student will not be in a custodial interrogation with an administrator. So first of all, if a parent comes to you upset, because I've seen this before, you should have read my student his rights, you know, very kindly and in only the way administrators can do. Let the parent know that actually in school, this is not a custodial interrogation. I'm just doing my job and investigating the situation. Now, law enforcement, it depends on a number of factors. And I, just for sake of time, I'm not going to go through each and every one of these, especially because those of you who are law enforcement, you know this. You get this pounded into you through post, and you understand what your responsibilities are and when an interrogation is considered a custodial. When you're working together, administrators and law enforcement, again, going back to what we talked about with searches, if the officer is actively involved in the questioning, then the SRO needs to consider whether Miranda is necessary. Okay, it may not be, but just if the officer is the one leading the questioning, then officer, you fall back on your training. If the questioning includes references to criminal charges that might be brought against students, SRO needs to consider whether Miranda is necessary. If the SRO is questioning the student for the purpose of determining whether to press charges, again, SRO, consider whether or not to read Miranda rights. If the officer is acting on his own rather than at the behest of the school official, if the SRO initiated the questioning. Okay. When conducting an investigation of an offense that took place at school, administrators, you should take the lead on questioning students. Keep the focus of the questions on the school infraction and not on a potential criminal sanction. This is especially important when an SRO is present. And again, SROs can be present. There's nothing that says that they can't. In fact, oftentimes SROs and administrators will question together where there's a potential crime involved. But if the SRO is conducting the interrogation, the student should know that he does not have to answer the questions and is free to leave, to go back to class anytime. And there should be no aggressive strong-arm tactics to try to elicit a confession when it comes from the SRO. Okay? Avoid lengthy interrogations where it's implied that the student can only return to class after a confession. And then always consider the age and experience of a student. Lastly, parent notification. I get this all the time. Well, as a parent, they were super upset that they weren't called before the administrator questioned the student, especially if a law enforcement officer is present. Okay? Just as a point of law, parents do not have a constitutional or statutory right to notification of searches or interviews by administrators, period. If an administrator, a school official, is doing his or her job, conducting an investigation, seeing it through, interviewing kids, reviewing computer security cameras, and a parent gets upset that they weren't called before the administrator talked to their kid, again, parents just don't have that right. Okay? Now, your district or your charter may require notification of parents prior to questioning by an administrator or law enforcement officer. So maybe there's something in your policy that does require that. So make sure you know your policy and you're following it. But just by way of state law, federal law, constitutional principles, parents do not have a right to a phone call before their kid is questioned by a principal, whether the kid is 5 or 15. Now in Utah, or excuse me, parents may be notified when searches and interviews are conducted by law enforcement for law enforcement purposes, depending on the age of the child. And again, that's not a requirement, but may need to be notified. If the child's under 14, for example, and SROs, you know this, the child cannot waive his own Miranda rights. The parent has to be there. Okay. I'm going to skip ahead for sake of time. We are woefully short on time, but I'm happy to send this presentation out to Sergeant Barnes and he can make copies available. These are just some protocols, some suggested protocols. Again, not anywhere written into law, but some suggested protocols for handling interviews of kids by outside law enforcement, because that happens a lot too, where law enforcement comes to your school and says, I need to interview this kid. So how do you handle it? How do you handle it if the kid's under 14 and a suspect? Maybe the kid's just a witness. So here's a chart that might help you walk through this. And just to end this section, I want to make it very clear that none of what I said precludes a law enforcement officer from lawfully detaining or arresting a student. If an officer wishes to detain or arrest a student, whether it's an SRO or an outside law enforcement officer, and then remove that student from school grounds, administrators don't interfere with that. That is considered an obstruction of justice. So administrators assist the officer with any lawful detention or arrest. Okay. Quick comment. I'll go ahead and send this. Someone said they'd like to have this slideshow. It's 4:25. I have 5 more minutes. Haven't gotten to the FERPA section, but I want to leave open some time for questions. So if you want me to continue talking and just leave the chat open and I'll read through it, then I'm happy to answer the questions as I get to it. Someone said, is that with any age? Yes. In your schools may have a policy, and it's always probably a good idea for administrators to notify parents if a kid's arrested. But once law enforcement arrests the kid, then it's law enforcement has taken the kid out of school and is it's not the school's problem. And that sounds really harsh when I say that, but school administrators, you may want to get information from the arresting officer. We're going to call this kid's parent. Can we tell him where he's being taken and or she and the officer's name? And that's within age. I don't see any other questions, so I'm just going to continue talking until I'm told not to. Quick FERPA review. Okay. FERPA review. Educational records are records that are directly related to students and are maintained by the school district or the school or the charter. Whole lot of information can be considered what's called PII, personally identifiable information, name, address, other indirect identifiers. Okay. The basic FERPA rule is that education records may not be shared without parental consent. And second to that, that parents have a right to see the record. Okay? Now there's some exceptions to this. And there's a lot of exceptions actually, but I only pulled out the ones that may apply to SROs. Okay? Information that's considered directory information can be shared even without parental consent. That's things like, and I will jump ahead and tell you what that means. A student's name, even an address, dates of attendance, grade level, a picture like a yearbook, for example, those can be shared without having to get parental consent. Law enforcement unit records, and I'll speak to each of these as I have time as I go on. If someone's a school official, and this definition of school official is much more broad than just someone who is employed by the school. Under a health and safety emergency exception, and then the Utah Department of Health and Human Services has access to certain information as well. So jumping ahead to law enforcement unit records, some MOUs will specifically designate the SROs as a law enforcement unit for purposes of school records. And I think that's a good idea, because what that means is records created by SROs for a law enforcement purpose and maintained by the SROs are not education records. And they can be shared freely with the law enforcement agency without having to get parental consent. It also means that students and or parents may be denied access to these records. I know you've all dealt with a parent asking to see some record, whether it's a written statement or a recording, where you do not want the parent to see it for whatever reason. So when it's created by the law enforcement, as in they create, the system and it's maintained, sometimes law enforcement have students write statements if there's a criminal nature, then those can be considered law enforcement unit records and not education records. Okay? Note, if the record is also maintained by the school, it's possible and actually quite common for a record to be considered both law enforcement and an education record. So just because the SRO had the student write the statement and then took that statement back to his agency and sent it on to the detective or to the prosecutor, if the administrator also kept a copy of the statement in order to conduct an investigation for administrative purposes, then it is an education record and a law enforcement unit record, which means parents do have the right to see it. And a school cannot share its copy with anybody else without parental consent. Just quickly, it's 4:30 right now, and I'm happy to continue talking for those of you who want to stick around. I'm also happy to end if there's another presentation or something right after me. I don't know that there is, but anyone in the chat want to just give me your preference? Red or Sergeant Barnes?
Heidi,
Okay.
thank you so much for sharing. And for those of you who would like to continue, please feel welcome to stay. Heidi, if that's okay with you.
For sure.
There's another presentation after this, and I feel like this information is really important, just like all the information you have shared. And so if it's okay with you, depending on your time, please feel welcome to continue.
I would be happy to. Yep. I'm going to get to security camera footage because that is a huge one. And someone mentioned in the chat, parents have rights to that if the school maintains the security system, and the answer to that is yes. Okay. So we'll talk specifically about security cameras here in a second. The school official exception says that school officials can share records with other school officials without parental consent. Depending on the way your MOU is written and the relationship between the SRO and the school, SROs may be considered school officials. And if you haven't yet, or if you're going to revise your MOU, I would strongly encourage you to write that in to your MOU, that SROs are considered school officials. And then you also have to include that in the notification, the FERPA notification that goes out to parents at the beginning of the year. That includes all of the directory information that parents can opt out of. And you're also supposed to explain who is considered a school official. And that's where you can say our SROs are considered school officials. That means if an SRO is considered a school official, then SROs can have access to student information, including electronic information, security cameras, and actual paper files. Where an SRO is not a designated school official, and an SRO, there's not another exception that applies, and there may be, but if there's not, then that really limits the ability of SROs to effectively do their jobs. If part of their job is really getting involved with students and making sure that they're helping. And maybe that's the way that the LEA wants it. Maybe it's a very arm's length relationship where the SRO is just there to enforce crime, not enforce crimes, but enforce the prosecution of crimes. And that's fine too. But if as an LEA, you want your SRO to be more involved and you want to share information about students and in student records, like was the kid in fourth period? Or was he actually not in fourth period, which was exactly the time that the 7-Eleven was robbed? That information can be shared with the SRO if the SRO is considered a school official. And keep in mind that an SRO may only access and utilize educational records for legitimate and necessary purposes. And that's true of any school official. So you can't just call someone a school official in order to give them access to anything and everything that they want to satiate their own curiosity, right? The school official should be accessing educational records for legitimate and necessary purposes. And when it comes to SROs, that purpose would be a law enforcement purpose or related to school safety and security. SROs may not use confidential student information for other purposes to provide student information to other law enforcement units or officers, okay? And sometimes that's gonna happen. Sometimes there's a crime. Say something happened on, say it was a 7-Eleven that was robbed during that fourth period. And the SRO has access to whether the kid's in school, but the crime has nothing to do with school. The kid didn't bring it back to school. There weren't a whole bunch of other kids at school. And this is a tough one. This is one that I know law enforcement agencies, you might hate me for saying, but if there's a crime that occurred off campus that is not related to school at all, and you want your SRO who is inside the school to feed you information about who was in school and who wasn't, and was this kid actually attending his 4th period class, you might need to get a subpoena. And when I say you, I'm talking to outside law enforcement agencies that are looking to investigate and arrest kids if they're not in the schools, okay? Because when it comes to the SROs access is strictly for the purpose of ensuring school safety and law enforcement at school. There's another exception, health and safety emergency exception. Schools can share records in connection with an emergency if knowledge of the information is necessary to protect the health and safety of students or other individuals. So say, for example, it's our 7-Eleven situation again, and instead of a burglary or a robbery or whatever, I'm not really sure what the technical difference is, but instead of the 7-Eleven being robbed, the kid has a gun and unfortunately ends up shooting people. And there is the kid still, he's on the loose. He ran out of the store and people are looking for him. In that case, an outside law enforcement agent coming to your school saying, I need to know if this kid's in school, or I need to know where this kid lives. I mean, addresses are directory entry anyway. But basically, in those situations where you have an immediate emergency, schools, you give that law enforcement agent anything they want in order to make sure that that crisis is contained. Okay. Also, just as an aside, I don't know if this is in my slides or not, but there are some schools, I know that Weber School District has a team that meets together regularly to discuss students who may be at risk, or a threat assessment team. And we have local law enforcement, not an SRO, but someone from the law enforcement, one of the law enforcement agencies we work with, sitting on that team. And we structure it in a way that it is a health and safety emergency exception by saying these are potential emergencies. This exception has been expanded to mean more than it has to be absolutely imminent. And there's some case law that supports a threat assessment team, including a member of the law enforcement agency, to talk about students who may be posing a threat at your schools. And that information about those students can be shared back and forth under this exception. And then Utah Department of Health and Human Services and JJS, under Utah law, which basically adopts FERPA, it says specifically that education records may be shared with the Department of Human Services, Utah Juvenile Court, and a school official if the student is in custody of, under guardianship of, the Department of Human Services, receiving services from JJS, in the custody of DCFS, or receiving services from DSPD, or under the jurisdiction of a juvenile court. So while this has nothing to do with SROs, I know schools are getting caseworkers from DCFS showing up all the time, asking for student records. And as long as you verify that caseworker's name, identification, where they're coming from, and that the student whose information is being requested is in the custody of DCFS or receiving services from JJS, then you can provide those records. So non-SRO access to education records comes up a lot. Say you get questions from law enforcement that are not SROs. Someone asked if the information sharing is reciprocal. Yes, but that would be, I'm assuming that you're speaking to the information sharing in a threat assessment team. In that case, it would be incumbent on the law enforcement agency to clear that sharing from their end. In our case, we have, and I can't exactly remember because I'm not their attorney, but they're the basis under which they can share information with us. And some information can't be shared, but they can share information about arrests or prosecutions that are ongoing of current students that we're worrying about. So going back to this non-SRO access to education records, law enforcement officials other than SROs may inspect and copy any public directory information maintained by the schools, such as yearbooks, phone directories, addresses, emails, anything that's included in that annual notice of what directory information is. Attendance records are not considered public directory records. And again, this is one that really makes law enforcement angry. But in my discussions with other attorneys at other school districts, it's hard to find an exception. So if someone's coming, an outside law enforcement is coming and asking you for attendance records in order to determine whether a kid was in class when an outside crime was committed, they're going to need to bring a subpoena. Outside law enforcement officials may not inspect or copy confidential records unless the student is under the care of and protection or receiving services from any of the agencies I just talked about, or it's an emergency situation. Okay? So if there's no emergency situation, the information can really only be released upon issuance of a search warrant or a subpoena. And I feel like that's really frustrating because we want to work together. We want to work with our communities to make sure that they're safe. And hopefully that's not too much of a burden, but that is the direction that I give my clients. Sergeant Barnes asked, what about enrollment information? Enrollment information is considered directory information. And so when a student enrolled and when a student unenrolled is public directory information and can be shared with law enforcement without parental consent or without a subpoena. Okay, security cameras. Take a second and take a drink here. Okay, so every district in LEA charter is going to have a different approach to security cameras. I'll just say that at the outset. Some districts' cameras are created and maintained by their SROs, and they have been designated as law enforcement unit records specifically. Keep in mind that a law enforcement unit doesn't actually have to be law enforcement. I know that there's some districts, in fact, I think it's Canyons, I don't want to misstate that, but I believe Canyons district currently or at one time designated its IT department as the district's law enforcement unit because it's the IT department that ran and kept the security cameras. And so when the IT department / law enforcement unit is creating and maintaining that camera and all of the footage, it's not an education record. It is a law enforcement unit record, which means, again, it's not governed by FERPA, which means, going back to those two rules, it doesn't, you can't, that sharing without parental consent, that rule doesn't apply, and giving it to parents doesn't apply. Other security cameras are created and maintained by the district, but they're shared with SROs as school officials. I know a lot of LEAs do that. So the actual creation of the security camera, the maintenance of the footage is maintained by the LEA, but the SROs have full access to it because the SROs are considered school officials. Some districts, and when I say districts, I don't intend to exclude charters, but districts or charters require any law enforcement agent to get a subpoena before accessing the records, whether it's their own SRO or not. So depending on who creates and maintains the recording, parents may or may not have access to the recording. Outside law enforcement may or may not have access to the recording, and SROs may or may not have access to the recording. If it's the school that creates and maintains the recording, parents are going to have access. If it directly relates to a student and it's maintained at school. Outside law enforcement probably won't have access unless there's some emergency or exception. SROs probably will if they're considered school officials. Okay. And that's if the LEA creates and maintains that security footage. Now, like I said before, it's entirely possible to have two copies of the same incident, and one's an education record under FERPA and one is a law enforcement unit record, not governed by FERPA, but governed by the law enforcement unit's policies. So for example, say it's reported that Johnny stole Bob's lunch money from Bob's locker while Bob was in class. Principal Pete and Officer Friendly, who was a school official, sit down and view the recording of the security camera that just happens to be directly across from Bob's locker. Johnny is not that bright. Sure enough, Johnny is seen opening Bob's locker while he surreptitiously looks around as if he's watching to see if anyone is coming. He reaches into the locker, clearly takes something out, then shuts the locker, shoves whatever he took out of his into his pocket and runs. Officer Friendly says, aha, he makes a copy of the recording for himself, designates it a law enforcement unit record. Then he provides to his agency a copy of it, provides to his agency the copy to open a case of theft. Principal Pete says, aha, and makes a copy of the recording for Johnny's files, calls Johnny down to his office to confront him about the incident. So you've got the same incident and you have two copies. One's considered a law enforcement unit record and one's considered an education record. Now, if Johnny's parents call and say, I don't believe that Johnny would ever steal anything. He's an angel. He never steals, he's a good boy. Nothing he does is, never makes a mistake. I want to see evidence and proof that he stole. Principal Pete is going to have to show Johnny's parents the video because it is an education record under FERPA, and under FERPA, Johnny's parents are entitled to see his education records. Okay. Now, if Principal Pete did not make a copy of the video and it was written over and the school didn't maintain it, Principal Pete would tell the parent, we don't maintain the videos. If you want to see what happened, you're going to have to call Officer Friendly. And then Officer Friendly may share it with the parents or may not. Okay. So just a last word on security cameras. What if there are other students? You're reading my mind. Getting to it right here on the slide. Let's talk about that. Real quick, when an SRO makes a copy of an incident and designates it as a law enforcement unit for purposes of a criminal investigation, and an administrator makes a copy, copies of the same record are going to be classified differently and treated differently. This is just what I got done saying. So just to reiterate what I just said. The difference is the purpose for which the copy was made. Okay? Skipping to this next fourth bullet point, administrators must show a copy of the record to parents if the video is maintained at the school and includes PII directly related to a student. Now, if there are other students in the video, the Family Policy Compliance Office, FPCO, has stated in informal guidance that parents can view the recordings even where there are other students involved. And you don't have to blur out the faces of the other kids if those other kids are just either background or even if they're part of the, say it's a fight. It's always a fight, right? The parents want to see because parents don't believe their kid would ever start a fight. So even if it's a kid that's involved in the fight, the FPCO has said, and this again is informal guidance, but guidance that schools nationwide have relied on, that a parent can come in to the school and watch the video and you don't have to blur out faces. Now, if the parent wants a copy of the video, there's nothing in FERPA, first of all, that allows parents, or rather entitles parents to copies of records. FERPA is about access. It's not about possession. So whatever the record is, there's nothing that says you have to give a copy of the record to the parent. But a lot of schools do because it's easier to send a copy than to have a parent come in. If the parent wants a copy of the video and there are other kids in the video, at that point, then you are going to need to blur those faces out and you can ask parents to pay for that. And parents, if they want it, should pay for it, okay? Also, FPCO has also stated that where there are other kids in the video, but they're not the focal point of the video, they're bystanders, then the record that we're looking at is not considered an education record for those kids. So say you have a fight, okay, and there's 20 kids standing around or, walking back and forth or whatever, then unless you're pointing out something about the student in the crowd, if you're just looking at the two kids there in the fight, all those other kids in the background are not considered to be the focal point of the video. And therefore, the record itself is not an education record for all of those kids. It's an education record for the kids about whom you copied or made a copy of the fight, probably the two kids in the fight. And I get questions on that all the time. So please feel free to jump in and ask questions if there are questions, or let me know later. I just have a couple more slides. That's all I have on FERPA. I just have a couple more that touch on something that Hasn't really been a big issue lately, but as of a couple of years ago was a big issue when the law changed about what can and can't be referred to law enforcement. So again, feel free to jump off, I won't be offended, but I'm just gonna spend the last 2 minutes reviewing what once upon a time was HB 239 and is now in law. So since 2018, schools can't refer students for truancies, disruptive student citations, infractions, and Class C misdemeanors. And I believe that that information is fairly well known and understood at this point. But just as a refresher, and because the law has changed a little bit in the last couple of years, infractions and Class C misdemeanors include disorderly conduct, giving tobacco to a minor, possession of tobacco, public urination, littering. These are just some examples of things that at one point in time had been referred to law enforcement, and law enforcement then could issue a citation or make an arrest. It's not, we can't do that anymore. We can't refer things to law enforcement for prosecution if it's a Class C misdemeanor or an infraction. And that is if it's committed by a student enrolled at the school where the offense occurred while school's in session. That just means a high school student can still be arrested for smoking in an elementary school playground in the summer. That was one of the flaws in the law. The first time it was passed, the next year that was fixed, because smoking, tobacco use is a Class C misdemeanor. And at the time that the law initially passed, it was like, well, that means that law enforcement can arrest a kid smoking on school grounds, even if it's during the summer. That was fixed the following year. So if the offense occurs at the school where the kid's enrolled while school's in session, or if it's the school-sponsored activity. The law did change again last year to say that, not last year, 2 years ago, to say that a district may refer a minor for a Class C misdemeanor if, so this is kind of your the teeth in the matter, right? We can't refer, but we can if the student refuses to participate in the school offered program and failed to participate in prevention and early intervention youth services provided by JJS. So say you have a kid that continuously brings cigarettes to school and the student simply refuses to participate in any tobacco cessation classes the school has offered, refuses to participate in the early intervention youth services offered by JJS. At that point, yeah, the school then can refer the kid to law enforcement if that's the only thing that's going to speak to this kid. But before referring a student, the school has to do a few things. They have to appoint a school representative, it can't be the SRO, to continue to engage with the student and the family throughout the process. They also have to include certain information in the referral. And that's like the attendance records of the minor, a report of what was tried, what we tried to do and the kid refused to do it, who the contact person is, who that school representative is, and then a report from JJS that demonstrated the student's failure to complete or participate in those intervention services, and then any other information the school district or school considers relevant. If you get to the point where nothing's working and there's this continual problem of whatever Class C misdemeanor it is, then you can refer, but you just have to make sure you follow these steps first. Now, schools can refer Class B or Class A non-person misdemeanors, things like assault, theft, trespassing. Well, theft if it's even under 500, trespassing, possession of drugs, arson, graffiti, harassing a service animal or livestock, if there happens to be livestock at your school. Pulling a fire alarm. Those are all things that we can still refer to law enforcement. We don't have to, administrators, but you can, okay? So what does this mean? Does this mean the SROs are required to sit out during administrator investigations of school infractions and lesser criminal violations? No. The law expressly allows an SRO to investigate possible criminal offenses and conduct. Consult with school administration about the conduct of a minor enrolled. That's huge. Please understand. And I think that this is continuing to happen. I'm glad to see that. At one point, SROs were like, fine, if I can't even do anything, then I'm just going to wipe my hands and sit back. But I haven't seen that happening as much in the schools that I work with, which is good. Please, SROs, continue to consult with the school administration about conduct. An SRO can transport a minor enrolled in school to a location if it's permitted by law. There's some JJS homes and mobile, sorry, I'm totally blanking on the name of these mobile crisis intervention homes that a student can be transported there if necessary. SROs can take temporary custody of a minor in accordance with this particular area of the law. And also, an SRO can always protect the safety of students and school community using reasonable and necessary force when appropriate, based on the totality of circumstances. And that's within the discretion of the SRO, and hopefully SROs aren't using force when not necessary. Again, those are the cases that get the horrible public relations nightmares that schools across the country face. But there are times when it's going to be necessary to use force, and SROs can do that. There's nothing in the law that prevents that. Okay? And then, of course, administrators may always refer an SRO to outside law enforcement when the student has engaged in a Class B misdemeanor or higher. So please understand that that's still an option. Okay. That's it. So just 20 minutes overtime. I'm happy to stick around with for questions if anybody has any. Feel free to email me, feel free to call me. That's my cell phone. I work from home a couple days a week, and that is the way I can best be reached. So
Heidi, thank you very much for sharing your expertise with us. This has been a phenomenal training. For those of you who would like a copy of the presentation, please email Shalise or myself, and then this Zoom will shut off at 5 o'clock. But thank you so much for participating. And Heidi, this has been phenomenal. We appreciate all that you do for education, and thanks for always collaborating with us and being the great leader that you are.
of course, thank you.
All right, thank you, everybody. I'll go ahead and we will end the training. Again, thank you, Heidi, and I hope you all have a safe and healthy rest of the day and rest of the week.
Thank you.